This is Professor McDonald, and this will be a discussion on Chapter 18, the investigator as a witness and ethical awareness. These will be my professor comments on this particular chapter. It's a very short chapter. My comments will be very brief. I've testified in numerous trials and court hearings at both the local, state, and federal level, even though most of my testimony obviously was in federal court because I was a federal law enforcement officer. It's important to understand as the criminal investigator on any case that when you finish your investigation, your job does not stop. Not only do you have to provide assistance to the prosecutor if the case goes to trial, and rarely do cases go to trial, but when they do go to trial, you're a big part of the preparation phase. And you'll also have to testify in court as to the results of your investigation. So it's very, very important to understand this as you go into the career. One of the key things, again, is that you are there to support the prosecutor. So I can recall one particular trial. I had multiple trials, but I think the longest one maybe went 10 days. We probably spent 6 weeks preparing for that 10-day trial. And these are long days, 10, 12 hours. Not only do you have to go through the evidence, get it orderly in a way to present it positively, in a positive manner to the jury and to the judge, but also you have to get all your witnesses lined up. You have to set up the logistics to get the witnesses to trial, find them places to stay, pick them up at the airport. I mean, there's a lot that goes into it. So understand that going into this career. The main thing that you have to remember is you have to be professional. You have to look professional, you have to act professional, you have to prepare before you testify. In other words, you have to be thoroughly familiar with your case and the facts of your case and the evidence, because you're going to be asked some very difficult questions from the defense. I mean, there's two processes that you'll go through. You'll go through direct examination, and that's by the prosecutor, and they'll call you to the stand and they'll ask you questions relative to your investigation, and it could be things you could be could be a suppression hearing where you're discussing the establishment of probable cause to get a search warrant. It could be the trial itself where you're testifying to what a defendant told you during an interrogation. It could be your observations during your crime scene examination. If you use electronic surveillance, it could be the process that you used to wire up an individual or an informant and send them in on an undercover meeting. There's a wide variety of topics that do come to play during a trial, and you as the investigator will be expected to not only be prepared when you testify, but to be professional and to look professional and to act professional. And this means you have to, I mean, this shouldn't surprise anyone, but you have to be truthful. There's no case that's worth being dishonest or lying about, because number one, if you get found out, there's a good chance you'll no longer be able to testify in that court again. You could lose your job, especially if you do it knowingly. You could be prosecuted. But the important thing is to present that professional image, be prepared in advance, and testify to the facts. It's that simple. Yes, you're going to be attacked, and the manner in which you handle that cross-examination by the defense attorney will go a long way, because the jury's watching you. They're watching the way you behave. As you know, a lot of communication is nonverbal. It's not what you say, it's the way you say things. And so you don't want to become combative. You don't want to argue with the defense attorney. You don't want to appear to be bored or to be trite in with your answers, like a smart aleck. Professional, informed, and you'll make a good impression not only on the jury and the judge. And it's important to impress these judges, because you'll appear before them many times. And I've had several judges that I've appeared for in certain hearings, and they give the defense attorneys a lot of leeway. And I had a judge even comment once in court that, okay, you've had enough time with this inspector. I've had him before me many times, And if he's telling you something, you can take it to the bank. He probably shouldn't have said that, but nonetheless, you build your reputation. Again, direct examination will be the questions that are asked to you by the prosecutor. Cross-examination will be by the defense attorney. He can cross-examine you on comments that you made during direct examination. They can't go on a fishing expedition or whatever. And they'll try to limit you to yes or no answers, and you answer these in the best way possible that you can without being argumentative. And if you have to elaborate on the question, do not let him cut you off. Go ahead and elaborate, but do it in a professional, clear way. You want to speak plainly. A lot of time, you don't want to speak using a lot of law enforcement jargon or language because the jury might not understand that, and then you're wasting your time. So speak very plain, clear, and be prepared. It's not unusual to get what they call in the textbook stage fright to testify until you, even if you have a lot of experience, you're expected to be a little bit nervous. That's normal human behavior. But the more that you testify, the more you become more comfortable with the process. It's important to remember, too, that you're not alone when you're testifying. The prosecutor has asked you questions. He's on your side. And if the defense asks you a question like a simple yes or no answer that can't be simply explained in that way, and you try to explain it, the prosecutor might object, especially if the defense attorney starts to harass the witness or badger you. When he does that, you be quiet. Let him stand up, let him make his point of law, his argument to the judge, and the judge will make a ruling at that point as to whether that line of questioning can continue. But it's important, I used to always look at the jury when I was testifying too, because they're the ones that are going to be asked the ones that are going to make the ultimate decision. A lot of times during direct examination, you'll get what they call open-ended questions. They're not yes or no questions. Investigator McDonald, when you arrived at the crime scene, can you explain exactly what you saw when you got there? Well, that's kind of open-ended, so I could kind of tell a story as to what I saw at the crime scene, who was there, who had been there before me, what did if there was a victim, what did the victim, how did they appear, these sort of things. And again, try to stay away from language that would not be common knowledge to your jurors, lawful, a scam, talk about scams and revolvers and a piece. You don't want to speak in the vernacular, speak in language that they understand. Every case has got a little weakness to it, to be honest with you. Maybe you wish you had a little bit better witness that is testifying to their observations during the robbery or whatever. You can't make up for that. You just try to explain it the best way you can. But what you don't do is want to mumble on the witness stand and make it appear that you really don't understand it or that you're trying to hide something. That can actually come across as even worse. And you definitely don't want to become belligerent. The textbook provides some pretty good advice. And don't forget that nonverbal language. If you look confident, it'll come across in that way through your eye behavior, your body movements. If you look bored, staring off like you're half asleep up there, those sort of things turn off a jury. You don't want to act that way. You don't want to be all fidgety. You just want to be natural. And if you prepared properly for your testimony, then you should be natural, you should be relaxed. And in that way, remember, you're serving not only the prosecutor in this case, but the government, the people. They represent the people. And so there's a lot of responsibility. And again, you always want to be neat in your appearance. Don't go in there looking slovenly, like a slob, in a suit that looks like you slept in for 2 nights. It's important now when you're finished testifying that you leave gracefully from the courtroom. Do not sit there and stop and shake hands and chat with the prosecutor and act like you're some kind of big shot. People pick up on this sort of thing. Another thing you can't do is you can't interact with other witnesses, and you'll be told that. Please don't discuss your testimony with other people. And that would include the press or anybody else. That type of conduct is outrageous. It'll get you in trouble, and then you could be accused of trying to influence other witnesses. So The book is very good about just warning you of some of the pitfalls that you can run into as far as misconduct, etc. Ethics is important. That's a euphemism for corruption and crime in U.S. police and law enforcement agencies. You have to make sure that you conduct your business in an ethical manner. No case is worth lying about or fabricating evidence or doing anything unlawful. You're expected as a sworn law enforcement officer to be to uphold the laws of the nation, so you yourself cannot ignore the laws. They also apply to you, and you actually are held to a higher standard. You don't want to be involved in any type of corruption or misuse of police authority, misconduct such as excessive use of force or violating somebody's rights. That's going to come back on you, and you could lose your job or even be prosecuted in some. So be ethically aware. And if you join a law enforcement organization, you'll frequently get ethics training. Don't laugh it off. It's important. Remember, professionalism is the key, and we can't have enough good professional men and women in our law enforcement today. And just remember that misconduct during a criminal investigation is a very serious thing. You could actually have a negative influence. They call it jury nullification. A case could end up in a not guilty verdict because they were influenced by their mistrust of the police witness. If they don't trust you as a witness when you're testifying, a jury won't pay any attention to what you have to say. As a matter of fact, they'll use it against the prosecutor in making their decision. And in today's world, we have standards. We have professional standards that are important for our criminal investigators. They should be conscientious, reliable, responsible, not only on the job but off the job. So you need great self-discipline and judgment. And that includes the individuals around you. Make sure that you hold your co-officers to the same standards that you have, the same ethical standards. And if you see something wrong, you need to report it in a proper way. That's all I have to say for this chapter, other than even though it's a short chapter, the information in here is very clear and easy to follow, and it's a very important chapter. This is also the last chapter in the book, and this will be the last of my professor comment videotapes.